Hello friends, in the series on the income tax cases, today we will discuss a case which is based on Rule 46A. Rule 46A talks about production of additional evidences before Joint Commissioner Appeals and Commissioner Appeals. When the assessee is not able to submit its evidences at the time of the assessment proceedings for one or the other reason, then the assessee has an option or a right under Rule 46A that he can write to the Commissioner Appeals that my additional evidences should be admitted, and the assessee has to prove that he was not in a position to submit these documents at the time of the assessment. That's why now, for the sake of principle of natural justice, these additional evidences should be admitted. When these additional evidences are submitted before the CIT appeal, the procedure is that the CIT appeal has to seek a remand report on those additional evidences from the assessing officer, meaning thereby that because since the assessing officer has made the addition and now the CIT appeal is going to take a decision on that order, so on the basis of principle of natural justice, the AO should have also a say on those additional evidences which have been submitted by the assessee. In the present case, the question before the Jaipur ITAT in the case of Madan Sharma versus Income Tax Officer, which was reported in 113 ITR Tribunal Short Notes 42, which has been decided on 21st June 2024, was that if the CIT appeal sends the matter to the AO for remand report and the AO also initiates the procedure of giving the remand report by calling information from the assessee and assessee also replies to the notices issued by the assessing officer for this remand report, then in that case it is the duty of the CIT appeal to wait for the remand report or to expedite for the remand report, and he cannot pass the order before or without receiving the remand report. In the present case, the assessee has submitted the additional evidences. The CIT appeal wrote to the AO to give the remand report, and after that the assessing officer made various inquiries from the assessee and the assessee also replied to those inquiries. But the learned CIT appeal, without taking the heed to wait for the remand report, passed his order. So the assessee was before the tribunal that this order is against the principle of natural justice and the commissioner could be said to have proceeded in violation of the principles of natural justice. When this matter was heard by the tribunal, now the question before the tribunal was that whether this matter should be remanded back to the CIT appeal or the assessing officer. Friends, when the matter is remanded to the AO, the rule is that the demand gets extinguished and the assessing officer has to make the fresh order, and then again the demand is created if the order is made against the assessee. So whenever there is a question that the matter should be remanded to CIT appeal or the AO, so in my opinion it should be chosen that the matter should be remanded to the AO. So the tribunal in the present case said that since the evidences were not appreciated by the assessing officer at the time of the assessment and now he has started issuing the notices on behalf of that additional evidences for taking the remand report. So in the present facts and circumstances, it is very much in the interest of the principle of natural justice and for the deciding the matter that this matter should be remanded back to the assessing officer for appreciating the additional evidences and then take the appropriate decision as per the law. So friends, the moot answer in this case is that the CIT appeal has to wait for the remand report if he has asked the remand report from the assessing officer before giving his decision. At the end of this video, once again I am repeating The name of the case is Madan Lal Sharma versus Income Tax Officer, and this case has been reported in 113 ITR Tribunal Short Note 42, and the matter has been decided by Jaipur ITAT B bench, and the date of the judgment is 21st June 2024. Thank you, friends.